Hello everyone, we are Group 10. Today we want to introduce a case which involved many female employees who fought against their employer. That is, Walmart's Stores Incorporated versus Dukes, which was decided in the Supreme Court on June 20th, 2011. We divided the presentation into 8 parts. And first of all, I will introduce the facts of this series of cases. These cases were about that a large number of the female employees at Walmart claimed that they were discriminated against by their supervisors because of their sex. The situation of pay and promotion reflected the different treatments on males and females, respectively. Moreover, 3 current or former employees who represented these women up to 1.5 million spoke out that they were the victims under Walmart's violation of the Civil Rights Act. Therefore, they insisted that Walmart should pay some reliefs, punitive damages, and back pay. How could they make the opinion with confidence? To know this answer, firstly, we should discuss how the decisions of pay and promotion were made at Walmart's. The arrangements of pay was subject to the higher authorities' consideration. For example, the hourly employees were limited more than the salaried ones to get the increase of wages. Similarly, who would be promoted was also the store manager's permission. Although there were some objective criteria to select the candidates of support managers, the managers usually make decisions with their own subjective sides. We can take the 2 named plaintiffs' experiences, for example, to understand the relation between the employees' benefits and the discrimination based on sex. About Dukes, due to some violations of rules, she was demoted to a greeter, where she started. However, the male employees who had done similar things weren't punished. What's more, the male greeters got more pay than she did. As for Arana, she was ready to be a store manager after the management's training, but later she was cancelled because of her sex. From these 2 examples, the treatments of higher authorities were ascribed to their own differential viewpoints on sex. There were many incidents not mentioned. Regarding these incidents, the female employees finally decided to stand up against the corporate culture and for the fairness of their rights. Hence, they initiated the litigation. The next part is the procedural history. The District Court for the Northern District of California affirmed the class certification regarding most factors, but denied the claim for lost pay because of the deficiency of proof. Then, both Dukes and Walmarts appealed. Subsequently, the Courts of Appeals for the Ninth Circuit affirmed the District Court's holding on the class certification. Therefore, the injunctive and the declaratory relief and back pay were affirmed. Nonetheless, the punitive damages were denied. Last, the Supreme Court of the United States reversed the Court of Appeals judgments because the circumstances didn't satisfy the requirements of the class certification.
Next part is applicable of law. Title VII of the Civil Rights Act of 1964 is protected employees from employment discrimination based on race, color, religion, sex, and national origin. The protection covered all the employment decisions, excluding recruitment, selections, and terminations. Federal Rule of Civil Procedure 23A is about the prerequisites of class certification. A class may sue or be sued as representative parties on behalf of all members only if they satisfy the 4 prerequisites. The first is numerous. The class is so numerous that joinder of all the members is impracticable. Second is commonality, which means there are questions of law or fact common to the class. The third is typicality. The claims or defenses of the representative parties are typical of the claims or defenses of the class. The last one is adequate representation. The representative parties will fairly and adequately protect interests of the class.
Now I'm going to introduce the next law application, Federal Rule of Civil Procedure 23B. Types of class action. A class action may be maintained if Rule 23A is satisfied, and if prosecuting separate action by or against individual class members would create a risk of A. Inconsistent or varying justifications with respect to individual class members that would establish incompatible standards of conduct for the party opposing the class, or a justification with respect to individual class members that, as a practical matter, would be dispositive of the interest of the other members, not parties to the individual jurisdiction, or would substantially impaired or impede their ability to protect their interest. And second, the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. Third, the court finds that the question of law or fact common to class members predominate over any question affecting only individual members, and that a class action is superior to other available methods for fairly and efficiently adjudicating the controversy. The matters pertinent to these findings include A. The class members' interest in individual controlling the prosecution or defense of separate actions. B. The extent and nature of any litigation concerning the controversy already began by or against class members. C. The desirability or undesirability of concentrating the litigation as in a particular reform. And 4. Likely difficulty in managing a class action.
The following part is issues, the court's order, and reasoning. There are two issues in this case. The first one is whether the certification of the plaintiff class was consistent with Rule 23A. The answer is being denied. The Supreme Court of the United States held that the respondent class could not be certified because the action did not satisfy the commonality requirements of Rule 23A2. This is the court's reason. The respondents, female employees of Walmart, alleged that the discretion exercised by their local managers over pay and promotion matters violated Title VII by disproportionately discriminating against women and leading to significant disparities between men and women at Walmart. The party seeking class certification has to satisfy four prerequisites listed on Rule 23A, which are numerosity, commonality, typicality, and adequate representation. The crux of the first issue is commonality, which is required by Rule 23A2. Rule 23A2 requires the respondents to demonstrate that there are questions of law or facts that are common to the class. To certify the commonality, the respondent's claims must depend upon a common contention that is capable of class-wide resolution. The respondents rely on three forms of proof. statistical evidence, anecdotal reports, and the testimony of a sociologist, Dr. William Spilbley. Unfortunately, they finally failed to offer significant proof that Walmart operated under a general policy of gender discrimination by local managers' discretion. A sociologist, as per Dr. Bilberly, testified that Walmart had a strong corporate culture that made it vulnerable to gender bias. However, he could not determine with any specificity if regularly stereotypes play a meaningful role in employment decisions in Walmart. And that is exactly an essential decision on which the respondent's theory of commonality depends. The plaintiff's statistical and anecdotal evidence didn't certify the commonality either. They are both too weak to raise any inference that a company-wide policy of discrimination is implemented by discretionary decisions made by local managers at individual stores. In sum, the claims by employees of Walmart that they had suffered a Title VII injury give no cause to believe that all their claims could productively be litigated at once.
Okay, now we are going to proceeding to the second issue, whether the respondent's back pay claims were improperly certified under Rule 23b2. And here is the court order. The employee's back pay claims were improperly certified under Rule 23b2, which did not allow certification of monetary relief claims that were not incidental to injunctive or declaratory relief. And here's the reason. First, claims for monetary relief may not be approved under Rule 23b2 unless the monetary relief requested is a minor part of the overall injunctive or declaratory relief sought. We don't need to determine if monetary relief claims can ever be approved under this rule because, at a very least, individualized claims like back pay are not included. Rule 23b2 only applies when a single remedy can benefit every member of the class. The history and the structure of the rules suggest that individual money claims should fall under Rule 23b3, which provides procedural protections such as predominance, superiority, mandatory notice, and the right to opt out. Second, however, the respondent argued that their back pay claims were appropriately approved under Rule 23b2 because these claims don't dominate over their request for injunctive and declaratory relief. This interpretation lacks support in the rule's text and goes against its structural features. The mere dominance of a valid B2 injunctive claim doesn't justify removing the procedural protections of Rule 23b3 or put potentially valid money claims at risk. Additionally, a district court would constantly need to reassess the class membership to remove those who are no longer employed and therefore eligible for a class-wide injunctive or declaratory relief. In contrast, in a properly approved B3 class action for back pay, whether the plaintiff are still employed at Walmart would be irrelevant. Hence, back pay claims should not be approved under Rule 23b2. And third, we don't need to decide if there are any types of incidental monetary relief that align with the above interpretation of Rule 23b2 and the due process clause because the respondent's back pay claims are not incidental to the injunctive they requested. Walmart has the right to assess each employee's eligibility for back pay on an individual basis. Once a plaintiff established a pattern of discrimination, a district court usually needs to conduct additional proceeding to determine the scope of individual relief. The company can then raise individual defenses and demonstrate the lawfulness of its actions. The Ninth Circuit made a mistake by attempting to replace this proceeding with a formula-based trial. Since Rule 23 cannot modify any substantive right, a class cannot be approved based on the assumption that Walmart won't have the right to litigate its statutory defenses against individual claims. Cases heard by the United States Supreme Court are decided by a majority vote. A single justice then writes the opinion of the case, which announces the decision and explains the legal reasoning for arriving at the outcome. Justices who agree with that opinion simply attach their names to it. A justice who agrees with the outcome but disagrees with the legal reasoning can write a concurring opinion. Those who disagree with the outcome can write a dissenting opinion. Only the majority opinion becomes binding legal precedent, although dissenting and concurring opinions are often used by lawyers for making legal arguments. Regarding the class in this case, Ginsburg agreed with the court should not have been certified under Federal Rule of Civil Procedure 23b2. The plaintiffs, alleging discrimination in violation of Title VII, seek monetary relief that is not merely incidental to any injunctive or declaratory relief that might be available. A putative class of this type may be certifiable under Rule 23b3 if the plaintiffs show that common class questions predominate over issues affecting individuals and that a class action is superior to other modes of adjudication.
Next part is dissenting. Justice Ginsburg, with whom Justice Breyer, Justice Sotomayor, and Justice Kagan join, dissenting in part. Rule 23a2 establishes the preliminary requirements for maintaining a class action. There are questions of law or facts common to the case. Even a single question of law or facts common to the members of the case will satisfy the commonality requirements. Rule 23a2, however, sets a necessary but not a sufficient criterion for class action certification. Therefore, the court explains Rule 23a2's threshold criterion with the more demanding criteria of Rule 23b3, and thereby elevates the Rule 23a2 inquiry so that it is no longer easily satisfied. In addition to the four 23a findings, Rule 23b3 certification requires to determine whether a class action is superior to other modes of adjudication. If courts must conduct a dissimilarity analysis at the Rule 23a2 stage, no mention remains for the Rule 23b3. On the other hand, each individual employee's unique circumstances will ultimately only determine whether she is entitled to back pay or damages, should not factor into the Rule 23a2.
Now I'm going to introduce group opinions. The influence Walmart store due to employers in class action. First of all, I will start with the resolve for the plaintiff having problem to show that every single woman was a victim of sexual discrimination in work. The Supreme Court considered that it was impossible for a plaintiff to show that every single woman was a victim of sexual discrimination, especially when women left most decisions up to regional managers. According to Rule 23A2, the cases should be assured to have the commonality between each case. Therefore, if Walmart defends itself, let it get the discretion of hiring to the regional manager. It will make the attorney of the plaintiff have the difficulty to prove that all the cases were the same, thus making it even harder for the female workers to prove that they were suffering from unfair treatment. Second, the impact on case modern vs. Walmart store is also a huge issue. The cases of Walmart also had a significant impact on the case modern vs. Walmart stores. The case was also considered to be a class action, with almost 400,000 women eligible for participation in a lawsuit. It is a sexual discrimination class action lawsuit, which challenged Walmart's denial of health insurance coverage for prescription contraceptives. However, different from the case of Dukes, the court is in charge of modern case made a positive opinion toward the granting of class action status. Third, the potential that the decision the court made could damage gender equality have to be discussed. The society strongly doubt about the decision the court made, worrying that it will make a huge impact on similar cases. For instance, like Costco, who was also confronted to a situation like Walmart, also sued for sexual discrimination against female workers, said it was more beneficial to the employers than to the employees, and even further from gender equality. In addition, the judgment made it extremely against women in work. The last one I would like to talk about is that the similar case Ellis vs. Costco Wholesale Corp. The case Ellis vs. Costco Wholesale Corp. also involved in Rule 23b2, and the case showed some hidden issues that discrimination could be other way. For example, not posting job opening for the top position in its store or having written promotion standard for a job could also be a type of sex discrimination. Next, the denial of Rule 23b2 will lead to some social problems. First, I would like to talk about what Justice Ruth Bader Ginsburg has said. Ginsburg said there was no need for the court to go through the evidence since the court could just reject the case by applying wrong procedure. If the court denied the evidence the plaintiff submit, it will lead to a problem which we will discuss in next topic. Thus, if a plaintiff party could prove it was not inconceivable that Walmart letting regional store managers make hiring or promotion just simply based on gender. Second, the problem that the court denying the evidence the plaintiff submit would turn out to be the plaintiff should submit more firm evidence than superficial evidence. The decision could make it even more difficult than usual when women want to defend themselves, since a court's decision would be like that the plaintiff should submit more firm evidence than superficial evidence. For instance, the percentage of women being supervisor would be weak, which is not strong enough to suit the employers. Third, giving the employer party chance to easily claim that there was not a discriminated policy. Professor Edson considered the decision significant not because the dispute whether Walmart discriminated against women. It's because it denied using Rule 23b2 to put together cases like this, because it is an efficient way to provide notice to each member and relieve them from enormous requirements. And the decision gave the employer a chance that as long as it did hiring and promotion to the regional managers, then it could claim that there was no discrimination policy. In the end, I would like to discuss the the statement the employer made and gender equality the plaintiff asked. The employer party claimed that once the court agreed with plaintiffs, then it would lead to a flawed or class action with weak evidence. It will not only cause a waste of judicial resource but also a serious problem for the employers. However, the advocates of women's side fear that the court's decision would deprive them of a powerful weapon against discrimination. In my opinion, both of the statements are convincing. Thus, how to balance the difference could be an important issue in the future.
The last part is conclusion. In the case of Walmart stores in Link vs. Dukes, 564 U.S. 338, the United States Supreme Court overturns appeals court decision. The court considered that plaintiffs failed to show that their proposed class shares a common question of law or fact required under Rule 23A. According to the court, the employees failed to offer significant proof that Walmart operated under a general policy of discrimination. In addition, claims for monetary relief are not eligible for class certification under Rule 23b-2. This case was a major setback for the Anti-Discrimination Project. The society questioned the decision the court made, since it was more beneficial to the employers than to the employees, and even further from gender equality. In addition, the judgment made it extremely against women in work. Finally, I will introduce the subsequent impact of this judgment on society. The ruling appended decades of employment discrimination law and raised serious barriers to future large-scale discrimination cases of every kind. In addition, the decision has already been cited more than 6,500 times in rulings by federal and state courts, including jury verdicts have been overturned, settlements thrown out, and class actions rejected or decertified, in many instances undoing years of litigation. Thanks for listening.